Today's conversation is about understanding equity financing. So, this is the venture capital financing rather than the bootstrapping that we were just talking about. This is when you take on investors, it's usually done through equity financing. So, we're going to do an overview. I know I said a complete overview here, but it's actually going to be pretty high level because it is a big topic. My name is Ellisha Blechynden. I'm a corporate attorney based out of San Francisco. I run a firm called Venture Point Legal, and we focus on startups, venture capital, and M&A. All right, so what we're going to cover today. Firstly, we're going to go over the common types of equity financings that are used for early stage companies. There's a few different ways you can go about doing equity financings, but we'll cover some of them, and mostly safes and preferred stock financings. Then we'll talk a little bit about term sheets, just generally. That's the first step in an equity financing is having a term sheet in place. And then we'll talk a bit about safes, and then we'll talk about preferred stock financings. Okay, so here's the overview. And I should just say, as we're going through, feel free to put your questions in the chat, and I'll pause every now and then and address the comments in the chat. Otherwise, feel free to save your questions till the end, or you're always welcome to separately ping me LinkedIn, email, and so on, and I'll share my contact information with you. Okay, so the financing landscape. If you're a founder, you have a startup, and you're looking to raise money, one of your options is to use your equity to raise money. And what I mean by equity is the stock in your business, the ownership of your business, essentially. If you're an LLC, it'll be membership units. If you're a corporation, it'll be your stock. Here I've listed out the three most common approaches to equity financings that early stage companies use. We've got the safes, which, based on the data, are by far and away the most popular way to raise equity for early stage companies. I'm not going to talk too much about convertible notes today, but I'll mention them here briefly, and preferred stock financings. So the safes are super popular, and what a safe is it's just a simple agreement for future equity. So you're not actually granting the investor equity now. You're entering an agreement that you'll issue them equity down the road, but you're going to set the terms of the price now. These are very quick and cheap from a legal fees perspective to negotiate. Most investors are comfortable with the YC form. Y Combinator originally developed the safe, or at least popularized the safe. And most investors are comfortable using the Y Combinator forms. There's no interest or maturity date. It's just a matter of the investor puts the money in now. You agree a conversion price now, whether that be based on a valuation cap or a discount or another method. And then the safe will convert in your next preferred stock round. So this is a efficient, easy way for startups to raise money. Convertible notes sit in between a loan or a convertible security. So they're different from a safe in that for starters, they're very investor friendly. And I usually deter founders and startups from using convertible notes. And the reason is that they're a debt, they're a loan instrument as well as the right to convert to equity. So the investor will have the option at a certain point in time. I either want you to repay the loan or I want you to convert me to equity in your company. Convertible notes typically have interest, and usually it's in the range of sort of 5 to 8%. They'll have a maturity date, 12 months, 24 months, sometimes 36 months. And, at the end of the maturity date, that's when the investor gets to make the decision on whether they want to convert into equity or have the loan repaid. They're much more complex than safes to negotiate. There's no sort of standard form like there is with the safes or for preferred stock financing. So they're usually, I mean, there are standard terms and the same clauses are typically included in most convertible notes, but they usually take longer to draft and negotiate, especially in comparison to safes. So yeah, I'm not going to talk too much about convertible notes today because I just generally deter founders and startups from using them, but some investors will insist upon them. And, that's okay. If the investor that you've lined up and you want to proceed with them, they're insisting on convertible notes, feel free to reach out. We can talk about it more. Okay, preferred stock financings. This is when you issue the equity directly to the investors. When an investor gets preferred stock, they get the comprehensive set of rights that go with preferred stock. And we'll talk a lot more about that later on in the presentation. But typically, a lead investor in a preferred stock round, they're going to ask for board seats. They're going to ask for control of certain governance matters for your company. The preferred stock financing rounds are the most heavily negotiated. They take the longest to complete. And they're just much more complex because you're giving away actual equity with those preferred rights, and you're dramatically changing the governance of the company, typically at most preferred stock financing rounds. Okay, so I'm just going to pause and check the chat quickly, see if there's any questions. Okay, I think we're all good. I'll keep plugging along. All right, term sheets. So when you're doing an equity financing round, when you're going out to raise money using your equity, the first step is a term sheet. And this is mostly, it's a non-binding agreement. There are some binding provisions, but most of the term sheet is non-binding. And it's just a starting place for the parties to come together and agree what they want the financing round to look like and what the key terms will be. Now, I should say with safes, because the forms of safes are generally, people are very comfortable just doing the Y Combinator forms. They don't often enter into term sheets for safes. I'll just go directly to the documents. But for other types of financings, and sometimes with safe financings, the first step is the term sheet. So the essential things you're going to cover. You're going to cover the company name, the investor names, and make sure you have their correct legal names. I know that sounds extremely basic, but you'd be amazed how often it doesn't get that right and people have the wrong name in there and so on. So making sure you have the correct legal names for the parties. You want to include the date. And sometimes with a term sheet, the investor will include like an expiration timeline. They'll be like, I'm offering you this term sheet. You've got 24 hours or 48 hours to sign and accept it. Just take note of things like that. Binding versus non-binding. So I touched on this a little bit. Most of the provisions in the term sheet are non-binding. We're just setting out a framework for what we're agreeing going forward. We're not entering into definitive documents, binding terms yet. That said, there are some terms in the term sheet that will be binding, and those usually are the confidentiality provision and the exclusivity provision. And governing law is usually binding as well. So for confidentiality, generally you're agreeing to keep the terms of the term sheet confidential unless the other party consents to, letting other people know. So how this sort of might play out is you'll enter into a term sheet with your lead investor, and then the lead investor will want to consent to you sharing the terms with other investors considering the round. And they'll want to control that process because they don't want to commit to being your lead investor and put all the money and effort into being the lead investor, and then you're just sharing the term sheet around, and then another person comes in and beats their offer. So they want to keep the term sheet confidential, and they want to keep that closely sort of held information. And yeah, similarly, for the company, they want to keep the information confidential so they can keep control of who's finding out about their financing and that it's not being publicly disclosed before it should be. Okay, and then exclusivity. So a lot of investors, lead investors in particular, they'll want to have in the term sheet something that says you're going to deal with them exclusively for a period of time. And you're not going to go out and look for another lead investor. You're going to stick with them as the lead investor. Now, you might look for other investors to also participate in the round, and maybe come in for smaller checks, but you're going to allow that lead investor the exclusivity for a certain period of time, to do the deal. 30 days is typical, 60 days at a stretch. This is really only for preferred stock rounds. You would never agree to this for safes or anything like that. So this is just some protection for the investors who are putting in money and time and effort. So that's why they ask for it. So a few pro tips. You want to make sure any of those exclusivity periods are reasonable. Don't sign up for 6 months or something. 30 days is a good starting point. That makes everyone, move quickly and stay focused. You should be able to do a financing within 30 days for a preferred stock round or a convertible note. Safes you could, usually do in a week. So, you want to keep those exclusivity periods as short as you can from the founder's perspective. Make sure you understand which provisions are binding and which provisions are non-binding. I sort of mentioned the ones that are typically binding, but sometimes they might sneak in something in there that's binding. So just make sure you're aware of what is binding, what isn't binding. Now, legal fee coverage, only offer that up. Well, don't offer it up. If the investors ask for it, it is pretty common to give it. You can decide at the time whether you want to give it or not. And by what I mean by legal fee coverage is that some investors ask for the company to cover their legal fees. And it's generally pretty common to cover for the lead investor, but don't offer it up. Make sure they ask you for it. And you also just want to be sure that you drop in the governing law and jurisdiction. Usually it's Delaware. Most tech startups and other types of startups that are looking for VC backing will be Delaware entities, and that's a good governing law. But just to put in your term sheet, but just think about that when you're preparing your term sheet. Okay, I'm going to quickly pause and look at the chat. Okay, great to see you here, Brian. Thanks for joining. Okay, doesn't look like there's any questions for me yet. And also feel free to, unmute and ask your questions if you like, or put them in the chat. Either's fine by me. Okay, next slide. Oh, went too far. Okay, here we are, safes. So like I said, with safes, you wouldn't normally do a term sheet. Sometimes people do, but normally you don't. There's different types of safes. They're all sort of standard forms. There's usually not a whole lot of variation on the forms of safes. Sometimes different investors will have their specific safe, or the company might have their specific form of safe, but 9 times out of 10, people just use the straight Y Combinator form. I know Carter has a form, and Clerky, I think, has a form, although Clerky might use the Y Combinator forms, to be honest, but generally speaking, people use the Y Combinator forms. And there's 3 forms of Y Combinator safes. There's the valuation cap, the discount safe, and the most favored nation safe. So for the valuation cap safe, really all you have to agree with the investor is what the valuation of the company is that you're going to include in the safe, and how much they're going to invest. And when people use the post-money form of safe, it's very easy to work out what that safe will dilute to. So my sort of pro tip for founders when they're using the valuation cap safe, which is by far the most popular safe, is just to track the dilution. So make sure you know how much of the company you're giving away. The higher the valuation, the less you'll be diluted when it converts. So that's the sort of motivation to push for a higher valuation cap. And then how that works is that when you do your preferred stock preferred stock financing down the road, the SAFE will convert at a price based on the valuation cap that you previously agreed. So typically, the SAFE valuation cap will be lower than the price of your preferred stock round, and those early investors who came in on the SAFEs will get the cheaper price and convert and get more shares because they got the cheaper price when it comes to that preferred stock round. Okay, the discount safe. So what you're agreeing with the investor in the discount safe is that the investor will get a discounted price in the preferred stock round that's coming up. So it might be 10%, 20%, 20% is the most common that I see. So you've got the next round, you enter into the safe, you agree your discount rate. When the preferred stock round happens, the safe holder will get the price in the preferred stock round, but discounted to 20% or what have you. Now, some investors ask to have both valuation cap and the discount, and then they pick whichever gets them the lowest price when it converts. So some investors ask for that. You can decide if you want to agree to that or not. Now, it's a little obvious, I guess, but the lower the discount, the more equity is preserved for the founders, the less you'll be diluted. So. And then the most favored nation safe, this basically means that when an investor gets one of these, they're going to get the best price when it comes time to convert. So you've got an investor with an MFN safe, the preferred stock round is happening. That safe holder will get the best price out of anyone in the round. So whichever is the lowest price that's being offered to any other investor, they'll get that. That's kind of a high level way of describing it, but hopefully that makes sense. And then another document that you want to think about with the safes is the pro rata rights side letter. So not all companies offer this, but some investors insist upon it, some companies offer it, some companies don't offer it. But included in the Y Combinator sort of package of documents is a pro rata rights side letter that gives the investor the right to participate their pro rata amount in addition to their converting their safe in the next preferred stock round. So their safe will convert. There's a preferred stock round happening. They get the right to participate their pro rata share in that preferred stock round as well. And that's what the Y Combinator form of pro rata rights side letter says. There's different forms of pro rata rights as well, but that's what the Y Combinator side letter says. It's very commonly used in safe investments. Okay, I'm going to pause for a second, have a little sip of water, and check the questions. Okay, and Nancy asks, is it typical to ask for discount rates? Yeah, it is pretty common that investors will, what a lot of investors ask for is the combined. They want a combined post-money valuation cap and discount safe. And the current Y Combinator forms actually don't include that anymore, but you can prepare one, your lawyer can prepare one easily enough. I have a form that I use for folks who ask that. So I wouldn't say it's typical, but it's somewhat common. I think that, Carter every now and then puts out sort of data about all the types of investments that they see through their platform. And like by far and away, just the valuation cap safe is like 90% of the investments that come through Carter. So the discount is actually pretty small at the end of the day, discount safes, but it's not uncommon for investors to ask for them. Okay, Deb asks, does the VC normally have an opinion on the valuation? Yes, they do. So it is usually the investor who sets the valuation that they want to come in at. And it's up to the company to decide whether they agree with that. It can go either way. Sometimes companies, have a really set sort of view on what they want the value of their company to be. But often I see investors come in and say, well, we're going to offer you this valuation. And then the company negotiates that with them.
Thank you.
Yeah, no problem. How they come up with these numbers, who knows? No, I'm kidding. The VCs and they have a complicated way they think about these things, and sort of different formulas on how they approach it. But yeah, okay. I think that's all the questions. All right, I'll keep moving forward. Okay, some additional terms to think about with safes, and these are items that are actually beyond the Y Combinator forms. So some investors try to negotiate side letters and different terms to the safes, and these are some things we typically see, and you can think about as, if you're a founder, whether you want to accept these, or if you're an investor, whether you want to offer these. Or ask for these, I should say. So qualified financing threshold, what that means is that when the safe goes to convert, you can't just convert it on any round. It's got to be a round that is raising, X amount of money. Maybe 5 million is the threshold. Sometimes investors say you can only do a round if you're going to have an institutional investor. I don't want the lead to be your cousin or what have you. So that's what it means with qualified financing. I'm coming in early. I'm doing a safe. It's early days. I want you to guarantee to me that I will have the major investor rights going forward. And what that means, if you're a major investor in, it's like a classification of investors in the preferred stock round. If you're a major investor, you get information rights, inspection rights, pro rata rights. You might negotiate a board observer seat or something like that. So just know that sometimes early stage investors, they're coming in at a safe. They're like, okay, I'll do the safe. I'm coming in early, but in that preferred stock round, you've got to guarantee I get major investor rights, and you've got to guarantee that now. They might also ask for an MFN, and this is a little different from the MFN safe, but related. This is a different type of MFN, which just says, I'm investing now, but if you go out and you offer anyone better terms before my safe converts, I want those better terms, whether it's a con note or some sort of fancy warrant or something like that. They want to get the best terms. Information rights, some investors want to get this straight away, and what that means is they're asking the company to keep them updated, provide financial statements, provide the cap table. They might ask about business plans and various different, pieces of information from your company. And I would just say, as a general rule, that's fine to give usually, obviously subject to confidentiality. But what you don't want to do is overextend yourself on information rights, that just prepare one set of information package that you share with your investors, and just have it at that. Don't be like, this investor needs these types of documents and this investor needs these types of documents. Otherwise you'll spend your whole life, complying with information rights clauses, which is not the main cause of your business, I would imagine. Okay, and pro rata rights. We talked about that a bit before with the Y Combinator form. There are different types of pro rata rights as well. There's sort of the standard pro rata rights is that the investor just gets the right to invest their pro rata portion in all financings going forward. Whether the company is doing another round of safes or is doing preferred stock financing, what have you. The investor wants to have those pro rata rights going forward so they can have the right to participate and maintain their ownership percentage going forward. And then sometimes you see like expanded pro rata rights, which is like a super pro rata right or something like that. And that generally, a super pro rata right, there's all different formulations to it, but a common one is the investor will say, you need to give me the right to invest up to 8% or whatever. 10%, 5% in all future rounds. And I just have that right regardless. That's a super pro rata right. Usually they're way too onerous and annoying for companies to deal with, but just know that that's a thing investors can ask for. Okay, so I'm going to move on to preferred stock, and most of the presentation will be about preferred stock going forward. So I'll have a little sip here. Quickly check the questions. Hopefully not putting everyone to sleep. Okay, I think we're good. All right, preferred stock. So when you're doing a preferred stock round, this means you're creating a new class of stock. It's going to be preferred stock, so it has preferred rights. And investors typically insist on having preferred stock. Sometimes you'll have an investor who's happy to come in on common stock, maybe friends and family kind of round, or sometimes an accelerator is okay taking common stock, but most of the time investors want preferred stock. And what that means is usually the thing that they have in mind is the liquidation preference. That's, generally considered the key sort of preferred right. And what that means is that they will get their liquidation preference multiple back before any of the common stock get anything when there's an exit. So, for investors, the main goal is usually to get an exit, whether that be an M&A transaction or an IPO or a direct listing or what have you. They are looking for the exit to get the return on their investment. So with the liquidation preference, the most standard liquidation preference is a 1x non-participating liquidation preference, which means that when there is an exit, the investor either gets paid out the greater amount of either their 1x return, so they get their investment back, or they convert to common and just get their percentage of the company. Now, everybody wants to have a successful exit that's more than the 1x. So this really only comes into play if there's a disappointing exit where the investors will be getting their 1x or less. But otherwise, the hope is that the exit will be for a value that's more than their 1x. So everybody converts, and then it goes to your ownership percentage of the company. Now, sometimes investors ask for participating preferred, which means they get their investment back before there's any other distributions made. Or sometimes investors ask for multiples. They might say 2x has to come back to them, or 3x, or what have you. But 1x is the most typical, and that's what you usually want to negotiate when you're doing a preferred stock financing round. And I should say the liquidation preference is actually also in the SAFE as well. So just so you're aware, the SAFE investors get that liquidation protection as well. Okay, dividends are also a right connected to preferred stock. They're very rarely paid out in, sort of venture-backed companies, but they can accrue. From the company's perspective, you want to make sure those dividends are non-cumulative. So, it's not really a big point, the dividends, just because they're so rarely paid out, but just so you know, that's something you should be aware of. Anti-dilution. So anti-dilution is kind of the flip of pro rata rights. So if you have a down round, the anti-dilution rights protect the investor, that the company will issue them additional stock so they can maintain their percentage holding of the company. And so, so if you have a down round, you get the investors have anti-dilution rights to protect them and maintain their ownership interest. And then on the flip side, there's pro rata rights. So in future rounds, which hopefully the valuation of the company is going up, the investor has the right to participate. They have to put money in. They don't just get it automatically. They have to put money in. So that's the pro rata rights on the flip. Okay. Now, the sort of key points when you're doing a preferred stock round, the first things you want to discuss with your investor is the amount of the round, the valuation of the company, and who the lead investor is going to be. That's kind of the things you want to answer straight away. When you are doing a preferred stock round, there is a set form of documents that the lawyers will use. Most commonly is what we call the NVCA forms, the National Venture Capital Association forms. And these are updated from time to time, but all VC lawyers are very familiar with these forms, and they're used on 90% of VC deals here in the US. There is another type of common forms used called the Series Seed forms. And sometimes if you're doing like a pre-seed preferred stock round or maybe a seed preferred stock round, you might use those forms. But 9 times out of 10, the lawyers are going to use the NVCA forms, which is a package of 5 documents. There's the charter, the purchase agreement, the investor rights agreement, the voting agreement, and the right of first refusal and co-sale agreement. And those 5 agreements will capture all the terms of the preferred stock and set forth the sort of governance of the company going forward. Okay. So, we talked a little bit about the economic terms of preferred stock. Now we're going to talk about the control terms. So with preferred stock comes changes to the control of the company. It's not just the founders anymore. The investors want to have a say in how the company is run. So the investors may ask for a board seat. The company doesn't have to grant it, but typically a lead investor coming in with a big check is going to want a board seat or board observer rights. Now, if you're a founder, you just want to be careful about what your board looks like. Are you going to be losing control of the board? Does that matter to you? Usually it does. Or are you, very comfortable with this investor? Sometimes investors can bring a lot to a board. They've been there before. They're working with other companies. They have experience. So sometimes having an investor on the board can be really helpful, and they can help you make connections in your industry and all sorts of things. So it's something to think about, weigh those considerations. There's also going to be protective provisions, and what that means is there'll be a list of items in the investment documents that say the company cannot do these things without the approval of the preferred stock. And maybe there's a preferred director. There'll be certain items that the investors director can sign off on, or there'll be certain items that the preferred stock holders directly have to vote on. And usually those decisions are made by a majority of the preferred stock, or whichever is the most senior class of preferred stock. But that's decisions like, whether you're going to have an M&A exit, whether you're going to change the size of the board, what your stock option pool is going to look like, whether the company can take on a big loan, things like that. So I usually advise my startup clients to keep that list as short as you can for as long as you can. Obviously, it makes sense to have the investors sign off. Well, they're not going to give up things like exits. Like they're going to want to approve exits, and they're going to want to approve the next financing rounds. Those are very hard to have excluded from the list. But there's other items on the list that you can carve back. So limit the scope of those items and make sure the materiality thresholds are high. Like for instance, with the loan, maybe the company can go out and get a loan for 50K without getting stockholder approval. But if they're getting a loan for $1 million, they need stockholder approval, things like that. Okay, information rights. We've touched on this a bit before, but preferred stockholders, information rights are really important to them because they've got LPs they need to report to. They have to report to the people who've invested in their fund. So, it's monthly and quarterly financial statements, and cap tables and Sometimes it's a business plan. Sometimes they want the right to be able to reach out and discuss matters with the management. And that's what's captured in what we call a management rights letters. They might also negotiate inspection rights that they can come to the company's office and take a look over the books in person. So as I mentioned before, with information rights, try and standardize it as much as possible just to reduce the amount of work you have to do there. And some additional things to think about is the drag along, the right of first refusal over founders transfers. And with those items, you want to be clear that you know what the triggers are and how those things can come about so you're not surprised. The drag along is when you have an exit or an M&A transaction that if a certain percentage of people approve, you can drag everyone else into that sale. So usually it's if the board approves it, if a majority of the common stockholders who are working at the company approve it, and if a majority of the preferred stock approve it. So if all those groups approve the transaction, you can drag all the other stockholders into the transaction and move forward. So it can be a very helpful provision to ultimately get that exit done. Right of first refusal. So most investors want to have a right of first refusal if the founders sell any of their shares. And what that means is, say, the founders decide they want to sell some shares, they want to buy a house or something, their company's finally valuable, they want to sell a little bit of their shares. Well, first you've got to offer those back to the company. The company will decide if it wants to buy them or not. Then the secondary right of first refusal goes to the investors, and the investors get to decide if they want to buy those shares over a third party buyer. And connected with that is co-sale rights. So say the company doesn't buy back the stock, the investors don't want to buy the stock from the founders. But the investors then have the right to co-sale with the founders. They can insist that the founders include some of their shares in the sale. So that's something to be aware of as well. Okay, I'll take another pause here and check the questions. Hopefully you're not all falling asleep. Okay, the typical rate of return. So the question here is, what is the typical rate of return you have seen for VCs go for when investing? It's an interesting question, not really a legal question, and I'm sure VCs would have probably a pretty different opinion from me. So the liquidation preference is one thing, but obviously the VCs aren't getting into the game to get their 1x back. They want to go, they want to make much more money than their 1x back. Historically in venture capital, there used to be sort of a method of like the funds would invest small amounts in lots of early stage companies with the hope that, generally speaking, like 6 would come back sort of 1x, 2x, two of the 10 would come back, maybe 3 or 4x, and then 2 would come back like 20x. That used to sort of be the model from what I understand. I think it's changed a lot recently. I think funds don't really want to do that sort of spray and pray method so much anymore. And I've seen a lot of investors rather commit a bigger check, less checks, but bigger checks to companies that they feel more confident will have, the rapid growth and a bigger rate of return. But I'm sure investors and VC funds perhaps have a different way of articulating that. Okay. Next question. Can you discuss a few strategies acceptable in the VC world for founder control? Yeah, great question. This really depends on the VC and their attitude, really. Some investors don't really want to be involved in the control of the company at all. They might have a few like key items that they want the founders to get their sign off for. But ultimately they're investing in the founders, in the company. and they don't want to be involved in the day-to-day or the decision making. So that is a lot of investors, to be honest. They're happy to just write a check and walk away and come back and collect their money at the exit time. Other VCs take a different approach. Some of them, they do want that board seat. They do want those additional management rights, access to management. They do want the long list of protective provisions that, a whole bunch of things the company wants to do. They want their sign off on. So yeah, and then there's those in between. So that's, it really usually comes down to it's a negotiation between the investor and the founder. And some VCs will say, write your check and I don't care. I mean, they won't say that, but that's their sort of view of it. And others will say, I'm not going to give you this money unless, you give me that board seat or what have you. And they'll say it in a nicer way than that. They'll tell you all about the different things that they can contribute to the company and why you should give them that additional control over the company. But yeah, it's really a negotiation. And I think it's, the founder has to think carefully about who they're investing with and, how comfortable they are with the level of control that they may or may not be giving them over their company. Okay, we've got a couple questions here. Um, Ziad, these are all great questions. I might suggest we speak separately about them. They're a little sort of off the legal topic, but I'm happy to chat with you separately about how to approach investors in this way. So let's talk about that. Okay. Yep, I'll circle back to that question at the end. Okay. Oof, that's a very specific question, Steve. I'll circle back to that later as well. Multiples. Okay, so the question is here about multiple types of stock, and the question, it's correct. You can have different classes of stock with different voting rights. And sometimes, we see the examples you're suggesting here that stock A would have, 10 votes and stock B would have 5 votes. We do see that. I will say investors hate it. They usually want everyone to just have one vote, whether you're common stock or preferred stock, and they get very frustrated when they see that the founder wants to have 10 votes to their one vote. So it's one of those things that certain founders can negotiate these types of voting rights for themselves. But it's not typical because the investors usually wipe it out pretty quickly. The question is here, does everything I spoke about apply to every country? Does it differ from country to country? So I'm speaking very specifically to the US market and how venture capital deals and equity financings are done here in the US. Now, that said, I work on a lot of international deals as well, and the basic terms are similar, but the documentation is often very different. So you just want to make sure you have legal counsel that understands what they're reviewing. But for instance, in Singapore, it's very common to see the Y Combinator forms used in Singapore deals for safes. The NVCA forms are very US specific. They're really only used in the US. In Europe, they use different documents. The UK does have sort of an NVCA equivalent, which is sort of used. It's not as commonly used. Different countries in Europe, they seem to mostly have bespoke forms that are tailored to the specific country and the rules, the corporate law in that country. So yeah, so what I'm talking about today, mostly, it does specifically relate to the US jurisdiction, but just know that if you're doing deals in other countries, that the basic terms are very similar often. Yeah, and there's a comment here about from a founder who doesn't want to get kicked out of his own company. That is a good concern, a legitimate concern. In a way, it's also kind of if you get your company to a stage where investors want to take it over, it's kind of you've really achieved something at that point. So um, just know that that is pretty rare, especially for early stage. Usually, like investors, they're investing in the team, they're investing in the founders. They want you to be there. They want you running the company. Otherwise, they're not going to invest in you. Now, sometimes that might change as the company grows and becomes successful, and they might think we actually need like a professional CEO running this company now, and 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 they might, boot out a founder CEO. At that point, it's not as common as people think. But yeah, I guess it did happen to Steve Jobs. But then he came back and was hugely successful. So, but yeah, a good question, and definitely something you want to think about when you're doing a preferred stock round. Like, can the investors, remove me from my role? If they wanted to, they usually don't want to. They're investing in you, and they don't want to. They don't want to kick you out. All right, I'm going to move on. So just quickly check the time. Oh, okay, we've only got 10 minutes, so I'll plow through this next bit here with a bit of speed. So the exit. So we've talked about a bit already. The investors are investing in you because they believe in your business, but also they want the exit. They want to get that return on investment. The main way to have an exit is an IPO or a direct listing or an M&A transaction. IPOs and direct listings are not that common these days. We've got some big ones coming this year, but mostly, it's pretty rare to have an exit that's an IPO. Most exits are M&A transactions. So you'll either be acquired by a big tech company or another startup, or you'll merge together, or maybe your startup will acquire someone else, acquire another startup, or something like that. So M&A is a big piece of the puzzle here for startups, and that's what most exits are. When you're doing the preferred stock round, you're going to negotiate what types of transactions will trigger a liquidation. They're called deemed liquidation events. And there you set out what types of M&A transactions will trigger the liquidation rights of the investors. So if we do this type of transaction, the investors will have to pay the money, that pay the investors back. That's a deemed liquidation event. Now we've talked a bit about the drag along. Just know that drag along provisions are often really useful when you're looking to do an M&A exit. You also, in the preferred stock round, you do start putting in what's called registration rights, which are the investors' rights with respect to an IPO, which I know seems a little crazy to be negotiating those terms while you're an early stage company, but what you do is you use the sort of standard language on registration rights just as the base, and then later rounds, say you start with your Series A, your Series B, your Series C. In your Series C and Series D round, then people actually start thinking about these provisions in earnest. So I wouldn't worry too much about them up front. And transfer restrictions. So separately from, a sale of the whole company, stockholders sometimes want to do secondary sales. They want to go out in the private market and sell their shares only, whether that be founders, whether that be investors. So you want to capture in the documents when you get to the preferred stock financing the restrictions around the transfers of specific shares. Okay, here's some strategies for success. So, and this, the presentation that I'm giving today is mostly directed at founders and startups. I can do the flip side presentation for investors, but here's just some strategies for success for founders. And if there's any investors on the presentation who would like the parallel for them, feel free to reach out. I'm happy to discuss that too. Okay, before you negotiate, before you go in to your financing round, whether it be a safe round, a convertible note, preferred stock financing, know your leverage and your timing. Like, have a sense of where your company sits in the market, how you compare to your competitors, the people who are doing the same sort of startup as you, and think about timing. Like, don't leave it too late. Don't be desperate to get this money. Don't be like, if we don't get this money, we have to fold. Giving yourself plenty of time to raise the money and take your company that way. If you can, get multiple term sheets before you sign one. Ideally, you'll have a handful of investors who are interested in you, and then you can pick the one that you get the best terms in. The investor who's willing to go, oh, I'm getting a message that my internet connection is unstable. So sorry about that if folks can't hear me. Uh, yeah, so get multiple term sheets if you can. And if you can't, just work with what you have. Sometimes you can only work with, what you've got. To that end, go out and build relationships with investors before you ask for them to invest in your company. Go to the networking meetings. Founders Bay is amazing for this. They offer up so many events for founders to go to and connect with investors. Do that. Go meet investors in person, introduce yourself, make sure they know who you are. Also work with your lawyers. Feel free to reach out to me if you need, or work with other legal counsel, but don't go into an equity financing round without some legal counsel, because you're giving up ownership of your business at the end of the day. Okay, during negotiations, focus on the key terms, focus on what's important. Don't negotiate every single point. Try and understand where the investor's coming from. They're giving you money. So,
Yeah.
think about where they're coming from as well. Document all verbal agreements. Don't do anything on a handshake. Make sure what you agreed is in a document somewhere. Set clear timelines and deadlines. Okay, and then after you've closed your round, you've got the money in the bank, the deal's done. Do make the effort to keep up regular communication with your investors. It's, respectful to them, but also could be helpful to you as well. You might catch up with an investor and they'll say, oh, I have this idea for a customer for you, or a connection, or what have you. Investors can be valuable to you in that way. If you have granted information rights, do honor them, and it's a good practice to get into anyway. Plan for your next round early. Don't leave it to the last minute. Obviously, build a valuable companies. The valuation is going up. It's a little obvious there. And do keep your cap table correct. I do a whole other presentation on the importance of keeping your cap table correct, but just know that that's super important. And the key reminders, the best investors are those who can offer you something more than just money. They'll write you a check, but they're also willing to promote you, connect you with others. Some investors, are great at that. That sort of broader role. Not all are, but some are. So just keep that in mind as you're going out to investors. Remember that the documentation for your preferred stock round sets the base for all future rounds. Every time you do another round of financing, the documentation will be revisited and renegotiated, but the initial documents set the groundwork. They set the base. And remember that term sheets, the first document you enter into is non-binding, but parties usually do stick to those terms. So don't just sign a term sheet thinking that you're not going to have to stick to the terms. Okay, so that's it.